Hi everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to talk about California contingency fee agreements in general. And I say in general because elsewhere on my channel, I have another video that goes over contingency fee agreements in California also. That video, however, is specific to California family law cases. I'm going to link that video right over here, or play it right over here, I guess. And I'm going to go ahead and link it down below in the description for you. So if you do have a California family law case and you're wondering if a contingency fee agreement rather can be used there, you can watch this video to get some background, but that video over here and the one that I linked down below, that will probably be of more interest to you if you have a family law case in California. So I'm going to talk, like I said, in general about what California contingency fee agreements are, what they have to contain, the requirements, all that type of stuff. So let's go ahead and get started. I'm going to hope that a lot of you, or hopefully most of you, have heard of contingency fee agreements before. You probably don't know it by that term, but the essential kind of idea is that, okay, well, the client comes to the lawyer, the client says, hey, I need some help on this guy hurt me, this guy stole my stuff, I've been injured, etc., etc. And the client basically says, well, hey, I need help, but I can't pay you. Tell you what, why don't I sign a contract with you, and then at the end of it, you, as the lawyer, will get a certain percentage of whatever it is that I recover. So maybe you've heard the phrase that the lawyer takes a third, or the lawyer gets 40% or something. That's basically what a contingency fee agreement is. So in California, there are requirements for what a contingency fee agreement has to contain. And the governing law here is going to be California Business and Professions Code Section 6147, Section 6147, which I'm going to link down below for you guys also. So go ahead and take a look at that if you're interested. But if you read over 6147, it's pretty obvious that there are certain requirements that the agreement, contingency fee agreement, has to meet. I'm going to go over those requirements now. So the first one is that, I guess, hopefully this is not surprising to you, that the fee agreement has to be in writing. And to have an oral fee agreement generally doesn't work. To have an oral agreement about anything, in my opinion, generally doesn't work. Writing is going to be preferred. It's preferred, but for fee agreements, contingency fee agreements, you have to have it in writing, period. So number two is that this writing that you have, this written contract, has to be signed by both the attorney as well as the client. I have another video on my channel called The Statute of Frauds. And if you haven't seen it, I guess, go ahead and, I'll link it down below as well and play a little bit of it over here. But the basic idea behind the statute of frauds is that there are certain conditions that have to get met in order to enforce any contract. And one of those conditions in some situations is that it has to be in writing and signed by the parties. So anyway, so requirement number one, fee agreement has to be in writing. Number two, the agreement has to be signed by the attorney and the client. And number three is that the client has to be given a copy of the contingency fee agreement at the time of signing. From the lawyer's perspective, I guess, I'll say that giving the client a copy is something very easy to do. The client holding on to the copy a lot of times can be difficult. Clients sometimes don't do that. So just remember, the client has to be given a copy. Whether or not the client holds on to it is not something that I, as the lawyer, can control. So we've established there has to be a written contract, signed, given a copy, etc. What does the contract actually have to say? So the first thing, I guess, or this is number four now, I guess. So number four is that the contract has to say what the contingency fee percentage is. So in other words, is it 30%, 40%? Is there a gradation? Meaning, like, okay, if the case finishes, at the negotiation stage, the lawyer takes 25%, but if it goes to mediation, it has to be 40%. If it goes all the way to trial, it's 50%, and so on and so on. So if there's multiple percentages, they have to get specified. If there's a single percentage, that has to get specified also. But the bottom line is that the contingency fee percentage has to get specified somehow so there's no ambiguity. So number five, I guess, I think that's what I'm up to now. Number five basically says is that the costs have to get specified. In other words, how are the costs going to be handled? You can also think of this, I guess, is the lawyer's percentage gross of costs or net of costs? So I'm going to go through a little bit of math here. Hopefully you guys can follow me. So let's say that at the end of the day, or at the end of the case rather, the defendants have to cough over $10 million. So they've done that. There's $10 million sitting in a pile. And the lawyer's fee agreement basically says that the lawyer is entitled to 40%. So, but at the same time, there's $1 million worth of costs that have been incurred in order to get the 10 million. What do we do with that million? Do we subtract it from the 10 million and then the lawyer takes 40% of 9 million? Does the lawyer take 40% of 10 and make the client pay the million, et cetera, et cetera? Like basically, how are costs allocated? Or is the lawyer's recovery gross of costs, net of costs, and so on? So that has to get specified somehow. A very common agreement that I've seen, a common version that I've seen, is that the lawyer takes their percentage off the gross. So if it's 10 million, the lawyer gets 4 million of that. And then the $1 million of costs are basically shifted completely onto the client to pay for. That's a pretty common kind of arrangement. But whatever the arrangement is, in your case, the fee agreement has to specify that. In number, I think 6 is what I'm up to now. Number 6 basically says, if there are related matters that are not covered by this particular fee agreement, how are those matters going to be paid for? So I'll give you a very common situation. So let's say that there's a car accident of some kind and that you as the client were injured in the car accident and you want to sue the person who caused the accident, for example. Let's say, however, that there's also a criminal case because the cops came along and found out that this guy was driving on a suspended license, that he was intoxicated, that he was driving drunk, something. So let's say for whatever reason there's a criminal case also, and in order to fully kind of guard against your interests, I guess, you as the client have to make a appearance in the criminal case too. Maybe you have to testify about something. You kind of intuitively want to bring your lawyer with you, but the problem is that the contingency fee agreement doesn't cover the criminal case. It only covers the personal injury part of it. If there are related matters like the criminal case, how is that going to be paid for? Do you pay your lawyer hourly? Do you add another 5% onto the fee, like the percentage? But regardless of how you do it, it has to get specified somehow. Related matters are charged on an hourly basis. Related matters are included. Related matters, are charged at, 1% per month or something. Whatever the agreement is, or whatever the arrangement is, rather, it has to get specified. So this next part is going to be a little bit complicated to explain because it involves going over something called MICRA. That's the Medical Injury Compensation Reform Act in California. It basically, in a nutshell, this video, like I said, not about MICRA. I don't do MICRA cases, but MICRA, kind of in a nutshell, applies in medical malpractice cases to limit recovery of, I think, non-economic damages. Don't mean to kind of tell you that. Don't quote me on that, I guess. It's not something where I am a MICRA expert. I don't do MICRA cases. But I need to explain what MICRA is because it affects the contingency fee agreement. So MICRA, like I said, is a law in California that goes over medical malpractice. MICRA has its own specific rules about what lawyers are able to recover. Like it specifies percentages. I think there's a ladder about, X amount of percent of the first 50 grand, X, Y percent over the next 100,000, and so on. So if you have a MICRA case, the requirements for contingency fee agreements are slightly different. But if you don't, then the agreements are even the standard way that I've just sort of described. So if you have a MICRA case, you want to look up what that ladder is. That's actually in section 6146 of the Business and Professions Code in California, which, as always, I will link down below for you. But if you have a MICRA case, just know that the contingency fee agreement requirements are slightly different because by law, the percentages are specified at a maximum. So hopefully all of that made sense. It's kind of a long kind of list of criteria, but just know that in California, like a contingency fee agreement can't just be anything that the lawyer writes up. There are certain minimum criteria that the agreement has to meet. And I guess this is probably something that I should have said way at the beginning of the video. But if you are the client and the contingency fee agreement that you signed doesn't meet these criteria in some way, let's say the costs are not specified, related matters are not specified, etc., you as the client actually have the option of voiding this contingency fee agreement with your lawyer. well, okay, so there are good things and bad things about doing it that way. One possible bad thing is that it does not actually get you out of pay your lawyer at all. Your lawyer is still entitled to a reasonable fee for all the services that they rendered to you. So, yeah, there's no free lunch, I guess, in that respect. So, last thing I'll say is that all the stuff that I've gone over actually does not apply for workers' compensation cases. So, if you have a workers' comp situation and you've signed a contingency fee agreement, all the stuff that I said doesn't actually apply. There are special rules for that that are separate. Later on, I might put out a video that goes over that too, but currently I am not. I don't have that planned. So anyway, Business and Professions Code Section 6147 is kind of where it's at, I guess, when it comes to contingency fee agreements. Take a look at that. This video, play it again if you want. But hopefully it's something that will at least kind of give you some general guidance. Yeah. So anyway, hope that helps. Thanks for sticking with me, and I will talk to you guys next time. Thanks.